Okay, I'm starting this video again. It's going to connect to the other one. However, I got the document. I believe I can read the document as long as my screen is still open for the picture right here, and until I can get another way of doing this here. And so what I'm going to do right now is I'm going to most likely read from that document while I have this video going on. It says Section 25. This is called the Judiciary Act of 1789. It is 1 Stat 73. You can do a PDF on it and do a Google search, and you will come up with it. Section 25. It says, being enacted that a final judgment or decree in any suit in the highest court of law or equity of a state in which a decision in the suit could be had, where is drawn into question the validity of a treaty, the validity of a statute, or of an authority exercised under the United States, and the decision is against their validity, or where is drawn into question the validity of a statute of or an authority exercised under any state on the grounds of their being repugnant to the Constitution, treaties, or laws of the United States, and the decision is in favor of such of their validity, not yours, or we're drawn into question the construction of any clause in the Constitution or of a treaty, a clause of a treaty, or of a statute, or of a commission held under the United States, and the decision is against the title, the right, privilege, or exemption specially set up or claimed by either party under such clause of the said Constitution, treaty, statute, or commission may be re-examined and reversed or affirmed in the Supreme Court of the United States upon a writ of error. The citation being signed by the Chief Judge or Chancellor of the court rendering or passing the judgment or decree complained of, or by a justice of the Supreme Court of the United States in the same manner and under the same regulation, and the writ shall have the same effect as if the judgment or the decree complained of had been rendered or passed in a circuit court, and the proceeding upon the reversal shall also be the same, except that the Supreme Court, instead of remanding the cause for a final decision as before provided, may at their discretion, if the cause shall have been once remanded before, proceed to a final decision on the same and award execution. But no other error shall be assigned or regarded as a grounds of reversal in any such case as mentioned aforesaid, than such as appears on the face of the record and immediately respects the before mentioned question of validity or construction of the said Constitution, treaty, statute, commission, or authority in dispute. So you see the creation of our document and where it is that we're trying to go. Creative writing is very important right now, and why you can't copy and paste something. As I stated, let me see if I can find it. 1 second here. Well, for one, it talks about the validity of the treaty, of the statute, but most importantly, also it talks about where it draws into question the construction of any clause of the Constitution or of a treaty. The clause, the construction. Terms of construction is used to create the law in order for us to basically get a clear understanding of the direction that the framers had in mind when they created that part of the law. So it's real important to understand this kind of stuff right here, because without understanding that, this is how we wind up going off course. That's why we don't have to do all of this copy and pasting. Now, hypothetically speaking, let's just talk about the clause in the Constitution. It's talking about any person, right? It's talking about, well, the statute is talking about a person. The Constitution under the 14th Amendment talks about a person, right? So these are clauses in a law. It says when the construction of a clause in a treaty or the Constitution or a statute being repugnant to the Constitution, and the decision is in the validity is in their favor, you have a right to bring this before the court. So this is why at the trial level, it's very important for you to bring all of your federal claims as a Moorish American into that court. If, hypothetically speaking, you get a denial, you already set up the federal court to go to the next level. But you can't be going up there with no stupid stuff. I'm not disrespecting anybody, but a lot of the stuff that I see people think that they can take to another level, only thing you get is an elaborate answer of why they're not going to grant us any relief or remedy, and then this keeps stacking up on the Moors. So when the Moor got a problem, they just start stacking that garbage on them. And that stuff stinks. It's like doo-doo. Because it really messed up everything. Why? Because instead of learning and perfecting yourself or staying in the dark room to develop the picture in order for you to see the light, they just rush out into it. And when you rush out into it, you get crashes. And you get fatal things taking place too. That's why the records for Moorish Americans is really bad. However, I'm here to deal with something different. I'm here to show you that all of that kind of stuff needs to stop. And the proof is in the pudding. The proof has to do with, one, what I'm talking about. Two, if you actually understand what I'm doing and then you execute it in that manner. This is just an intro at this present time. Why? Because the school is opening, but I want to see what's on you guys' mind. That's why I'm asking for comments, statements, suggestions, and not really a debate, because when I go live, we can have that discussion for debating. Okay, that's not a problem, because we need to, in the end, bring about a round table. I don't just have my school. Like I told you before, I'm into the people. So that means some kind of round table discussion needs to go down. Okay. So so we went into the treaty. Okay. We went into, we talked about in the Judiciary Act. That's a very important instrument for you, Moors. Very important, because it talks about all those things. Now, you're going in there with the Zodiac Constitution. Okay? That Constitution's on the federal seal. Okay? Now, I know most people even haven't done that. What is the duty, or what is the authority when things are deposited at in the Library of Congress, do they have, and the validity and force of what's in those records? We know it has law to do with it, because when you mess with copyrights, you have a problem with other people. However, they'll state to you, well, we're not interfering with your copyrights. Well, the question would be, if you're not interfering with my copyrights, it's not a matter that you're interfering with the copyright, but the copyright itself is the instrument to challenge the authority of the terms of construction that is used to refer Moors as Negroes, and to challenge it and to prove it to be otherwise. Okay, this is what the Zodiac Constitution does. As you remember, when I talked about, I said the document of white supremacy. Now you know where we at today. You got all kinds of people that's in office today. This is not a white thing anymore. However, the institution is based upon, from the early days, the institution is still based upon those documents of the 48 Union states, which is why all of the laws are what they are, which is why they had to create a special law called the 14th Amendment in order to protect Moorish Americans. Well, basically, and you couldn't protect Moorish Americans because Moorish Americans are not Negroes. So this was to protect their interest in their property when Mr. William Bingham said, let me enlarge your power by you taking these individuals, these slaves, and making them persons, then we can make them citizens, meaning that's for the purposes of taxation. Remember, it was 3/5 of an individual. So if you got 3/5, you needed 2 more fifths to make a whole fifth. So if you look at the Buck Act of 1940, you took 3/5 and 2/5 put together. Now you got 5/5. Now you got a whole person. Okay, so, but these are all old laws that they don't talk about. It's like if you get an old law dictionary, you talk about the dumping acts. Okay, that's not garbage, but then again, it is. The dumping acts in the early 1860 at 65 had to do with dumping niggers in another state. So they passed laws called the dumping acts. Get you some old Black Law Dictionary, look up the dumping acts, and then go further into it. You'll see it was about Negroes coming from one state to the next state. However, we're not trying to escape that. And this is why I don't like to go out to sea. Why? Because the law is already established, and it already says that in our information, more is referred to as. I'm not saying I'm that. It's referred to as. However, remember we just read in the Judiciary Act when it talks about a clause in the Constitution, in the treaty, okay, in the statute, okay, that would be contrary. It's a clause. So that clause that pertains to that, how could it be pertaining to this? But it's important, again, that your ability to write creatively establishes those grounds. And in between it, as you create the body, you put case law in there. You started out with your skeleton, which is what we got now. But when it's all done, your skeleton starting out is your affidavit. Then behind that, you got your memorandum in support. Okay? Now the judge is going to rule on that. But because I just discussed that, I want to take it also in another direction. Instead of just having this as an affidavit in support, let's make this an affirmative defense for prosecution. However, I want you to notice this also. Take note of this. A civil case that begins and you come in to answer it, the same as a criminal case. However, in civil proceedings, instead of coming in with an answer, you can come in with an affirmative defense. Now, I also had another way of dealing with something on the criminal level too as well. In terms of, okay, they say what? Innocent or guilty. You know, I say innocent with an explanation, which is basically an affirmative defense. However, they wouldn't expect you to say anything like that. They say, oh, you're innocent or you're guilty. If you say guilty, it's all right, adjourn. No, innocent with an explanation, and I have an explanation right here. Which is your affirmative defense. You have to you already have it on, you clocked it in inside the clerk's office, and you have a copy right before the court to give prosecution and a courtesy copy to the judge. Thank you, Your Honor. I think we'll adjourn this here until we get an answer. I appreciate that. All right, so the bailiff, you come, you pick up your copy of your affirmative defense or your answer that you clocked off in the clerk's room, okay, because you came in late that day. So you want the record to reflect that you didn't go to the prosecutor's office, that you're giving them a copy in court, and you're giving also the court a courtesy copy. Always try to give the judge a courtesy copy, because this is not adversarial. This is civil. But the problem is that is our lack of knowledge. We get angry inside. And so because our anger and our emotions, most of the emotions, because of history and the mindset of the Negro mindset, the black stuff, you got to get that out your head. Moors are not black, Moors are not niggas. We're talking nationality. And we all have the same nationality, whether you consciously know this here or unconsciously don't know this here. You're still our brother. We're still one. However, the time has come for you to proclaim your nationality. My doors stay open. Okay. However, I'm a school, and I would never tell a brother or sister who wants to learn the law coming my way, say, well, brother, I want to proclaim my nationality. I tell you this. Sure, you can get a nationality card from this organization, the Moses Sons and Daughters of Light. However, I'm requesting you, I'm not asking you, I'm requesting you to find you a temple to join, so you can pick up your Moorish Quran and get your papers of an official temple where you can be registered on the Great Register, because that's what this case law is at. When you win a case, then you're put on what they call the Great Register. Okay? And it never comes off of there. So it's very important that you understand and know this here. Hold on for 1 second. So the Great Register means a hell of a lot. And so therefore, when you go to the temple, you put on the Great Register. Where's the Great Register at? You got the local register inside the temple, which are registered there. Then it's sent to the headquarters in Chicago. That's the Great Registry. So when you want a trail or a genuine link, see, because remember, as I spoke inside the document, that's the most important part to eradicating the Negro status, the genuine link, either through Clock of Destiny, membership, Zodiac Constitution, or Moorish Science Temple. Nevertheless, you still can create a genuine link because you are what your forefathers are beyond the shadow of a doubt, namely Moorish. So whether you went through any organization, I'm only being truthful with you, whether you went through any organization, you still what your forefathers are, namely Moorish. However, your ability to defend yourself, that's the next point, next issue here. Okay? So that's very important that we understand this here. But those two groups that I know of, there's other groups out here too. The US R, I forgot what city they're in, but they seem to have been doing some great work. They're doing a lot with travel and stuff like that. You got a lot of brothers doing a lot of different things. However, like I said before, I'm a school teacher. I teach the trades, and I'm also a paralegal, so I teach the law. Or for educational purposes, I teach this law and make sure that my brothers and sisters, Moors and conscious and unconscious, who come on my site and want to learn as well as know more, then we take it to the next level. So, again, we don't even need to go any further than sticking with the Judiciary Act of 1789 when it comes to creating our instrument. So now it's your duty to find a clause in the Constitution that's contrary to what you got. It's your duty to find a clause inside the statute that's contrary to what you got. It's your duty to find a clause within the treaty that says it's contrary to what they're doing. That's your duty. Now, not only is your duty to find that, but then you also got to look at it's your duty to create a body of writing to support your claim. Okay, that's legitimate. That's the order, like I said before. You write to the audience that's going to be reading it. If you're not writing to the audience to be reading it, and you think you're just writing it regularly, you're going to lose out. You're going to lose out. Now you're going to look at it. So as I see different types of, there's no continuity in your statement. There's no continuity in your sentences. There's no supporting authority to validate your claims that's relevant. I'm going to just put it in the garbage. And this is what's been happening with most brothers and sisters when they call themselves filings. And this is what we got to get past. And this is why, again, I'm teaching what I'm teaching. All right? As I said, it's for educational purpose. But it's important that you understand where I'm coming from. And like I said before, once I'm done with this video, I'm requesting, asking you to comments, statements, challenges. It doesn't matter. The proof's in the pudding. In the end, we're going to all meet up in the courtroom one of these days too, and I'm going to be there with you. So we're just starting now. This start that we're starting with right now is dealing with the affidavit of support. And then we talked about the memorandum and the memorandum of law that goes behind it. We talked about the questions that will be presented because you got 5 points, so you got 5 subsections of a summary of the question and the answer. But now, out of those 5, you got to give me also 5 subsection also points in terms of authority and law where you got my IRAC. You already got the issue up top. We did that one, okay? And we did a summary of the answer. But now we deal in reasoning. Now, why did the court reason that way? Or why should the court reason this way? So we done passed I because we did those 5 subsections. So when we go to the first 1, 2, 3, 4, 5, we're dealing with reasoning. Why the court reasoned in that way, or why the court should reason in this way. And when we show those reasons, then we're going to get our analysts of these cases that support our argument, the point that you're raising before the court. But that's your duty to do the research. We do that in school. Okay, we do legal research and writing. We deal with group. We break out in breakout rooms, and we have to discuss. Okay, why? What direction should we go in? Looking at the wording, looking at what was before us. Okay, how will we research this here? So these are all group efforts where we get together. Why? Because we have to break the ice, create the camaraderie to enhance the family to be more secured. Okay, and then after we're able to do that, that makes the school stronger. Okay, much stronger. Our brothers, not only will see, well, we have some strong brothers. Okay, We got some physically strong brothers. But if you understand how the system is, they don't want those big brothers to know what I know. See, because when those big brothers, if they having some kind of police contact, first thing they come out with a gun on them. Why? Because he big. But this big guy now, he's not even advancing or showing any aggressive attitude towards when he's dealing with them. He's coming from legal jargon. Don't you know he did like a Muay Thai move on him, okay, or a jiu-jitsu move on him. He expected that guy to get all aggressive and act like some idiot, quote unquote Negro, but he's intelligent. He understands the law. He knows what his rights are. He knows what his birthrights are and his nationality. And he has an intelligent conversation regarding whatever he's dealing with, from a traffic stop to being in the court proceedings. His demeanor is not like you expected it to be anymore. It changed. Now they're unified mentally, our brothers and sisters, on an intellectual level. Now we start to do business. Now we start to sit down and start make plans for economics and change, because the mindset is changing. That's what's important. So this is where I want to go at with all of this here. All right. And as we do this, we activate chapter 25, chapter on unity. Ye are the children of one father provided for by his care, and the breast of one mother have given thee suck. Therefore let the bonds of affection unite thee and thy brother in thy father's house. See, we got one mother and one father. Okay? But they're in adversity, and they need our help. And they're in trouble, and they need us. And we need them, because they're our brothers and sisters. They're our aunts and our uncles and our cousins and all of that. So it's important that we educate them and that we educate ourselves. So in educating ourselves, we change our conditions. Only poor people are uneducated. A person who becomes very enlightened in his mind can't stay poor too long. If he has practical ideas that is right thinking and to get results, that means it had to be put through mathematical tests. Mathematics don't lie. Mathematics do not lie. It stands to be proven the truth. So that's all we need to do. Once we start to do that, we'll get somewhere. So now, before we go a little further, and I'll move this video to something else. I want you to go to YouTube now and look up Memorandum of Law and listen to them say about the Iraq that I just discussed with you. Okay. However, it's your duty to create a Moorish writing. Moorish writing and regular writing, trust me, it is not the same. You're not going to get the same results. And when you do the right Moorish writing, you're going to open up some eyes. And in opening up certain eyes, you're going to get a aha moment. Aha. Someone just caught on. Granted, case dismissed because of that aha. You know, when you was a child, it was games we used to play. It's called hot peas and butter. So, when you find that you get a belt and you got this thing you'll hide. As you're trying to find it, you get hotter and hotter and hotter. Everybody trying to find it. But when you find that belt, you got to whoop whoever back home. It's called hot peas and butter. All right? So when you find your birthrights, you get hot. When you really find it, somebody gonna get their butt toe up. Okay? That's how that's gonna happen. Somebody get their butt toe up. We're gonna start all over again. So again, stay with the Judiciary Act, because that's the most important part. Now, if you Google it like I just said, you're gonna have cases that support it. I'm not saying that you're gonna understand that case 100%, because you probably won't. Okay? But you're gonna get some historical cases concerning the issues that we just raised, okay, where a clause in the Constitution is out of check or out of whack, or a clause in the treaty has been breached, but they saying it has not been breached, or they're not even saying it hasn't been breached. They basically say that Moors, or those who claiming to be Moors, aren't really Moors, because of the way that they put in their thing. And they say, oh, this stuff, that's 200 years ago, or that was on the waters. That ain't got nothing to do with now. That's because of material that you need to, again, like I said, substantiate your argument, and know the audience that you're reading to. If you knew, you would know that first and foremost, whenever you argue in that treaty, so that because of you're doing it on your own, first you need to go to the volume of books that shows that, or books that shows all treaties enforceable in the United States. Then find the Moroccan Treaty. Copy that first page, copy the other 2 pages in between on right behind that. Then go to that section of the book, copy the Moroccan Treaty of 1836. Shows you that's in full force. It don't matter which one it is. Okay, now we got that. You need to have an authenticated copy from the Library of Congress, the Moroccan Treaty of 1836. You need to have an authenticated copy of the American Constitution, of the 7 articles and the amendments. I just actually went to the library the other day and I found it. And I copied it and put it in my, I'll probably most likely put it online. But it's the Constitution from 1789 and the 10 amendments in the Bill of Rights, but it went up to 12 for 1791. Now, those of you who do know the Zodiac Constitution, it talked about disproving our truth. Produce your Constitution from 1789 to 1863 in defiance of my statement. But it's your duty now. Remember, he said from 1789 to 1863. So where do we fit in there? Back there. We're not really going there anyway. We got to go even back before that. You need to go into Articles of Confederation because you still got Article 4, Section 2. It talks about free inhabitants, okay? Having the same rights as citizens. Then it goes over here and it talks about citizens, foreign citizens, citizens of other states, citizens of different states. It's technical. It's very remember clauses, terms of construction. This is how they trick us also. Because as you know, you put it in the book, most people don't get it. Okay, so it's really important that we understand this here. Okay. So it's stay on it, do your research, do your study in this here, and just stay in that area as we develop and move along. So at least your work will be clear. You'll basically understand what's an affidavit. You understand what's a memorandum of support. Also, look up a notice of motion. Put notice of motion and go. And remember, I said this got to be done in YouTube in order for you to get the video to go with the work. Okay. And the reason why I'm saying this is because I'm very impressed that some lawyers have come out and some other law people, they putting up their stuff on the website, but I wouldn't say that they basically are legal or know anything that much about law, but they doing what they do. I give respect to everybody that's doing what they do. I'm doing what I got to do. And I want to make sure that we all understand this here. So stay in this area right here in terms of how to write and put this together before you want to venture off. Because like I said, there's all kinds of ways you can turn things around. You can come in as a defendant, even in a traffic matter. You can come in as a defendant, but you could come in with, when you put an affirmative defense in, you become the plaintiff and they become the defendant. Which is a totally different route. So like I said, go to Google, YouTube, and look up affirmative defense. Okay? So you'll see how to change things around. Now, let's say hypothetically, you put something in, but you don't have a response. You don't know. There's a rule for everything. If a person doesn't respond, you compel them. Or you preclude them from introducing it if you got to go any further. If you got to go any further. See, we're just talking at the present time. There's a whole lot of different steps, man. We got, like I said before, we got discovery. We got bill of particulars. We got interrogatories. And then we got inspection of documents. Things physically, things you got to do that you do it. You go down to their place. They come to your place. We want to get all of this here done before trial. Because what we want to do is move with a pre-trial motion to dismiss. I know, as I said before, brothers say they don't. Some brothers said, we don't do, Moors don't do motions. You don't do motions. I do. And if you don't, like I said before, do a brief. Put in a brief. A brief is settled law. Look up a brief. Do a YouTube brief. What is a brief? All right. And then structure your brief accordingly. A brief is not a memorandum of law. A brief is totally different. Okay. You do briefs in the state and you do briefs in the feds. So it don't matter what court you're in. You still gonna wind up doing a brief. Okay? However, those that don't do the things I'm talking about in this, that means your strategy is limited as far as your techniques. Because let's say I made a mistake along the way because I had somebody helping me and I found myself losing. Now I got a little knowledge and I want to come back on that same point that the judge already ruled against me. Because you don't do motions, you won't get a chance to do this here. I move to re-argue. That's a motion. It's not a brief. It's a motion. I motion to re-argue or reconsideration. And then I show my points because the judge already made his rulings and he showed why this is being denied. But you're saying reconsideration, let's say you got new evidence or you have a better understanding to construct your writing that he would see your point of view as well as the authority that you laid out to say, aha, you got that. And he reversed the decision. Okay, that's motion for reconsideration or re-argument. And then there's, like I said, there's a whole host of different things you could do here. Let's say you're in a housing matter and you was, I'm not getting off the point neither. Let's say you're in a housing matter and you're arguing that the service was no good, okay? And the judge ruled against you. But before he rules against you, it's your duty to say, Your Honor, the service is not good. He's gonna say, well, it appears to me that the affidavit of service is signed by the process server, Your Honor, but it's not. I would like a traverse hearing to establish the facts that this is just a recital of the form and not meeting the requirements of the legislation. He just cited that he came here this day, and this day. And what the law requires him to do, he did not do. So I'm asking the court for a traverse hearing. The judge can't tell you no. So now when you question this guy, if you go into the statute in regarding service, you just can't fill in the box. You have to state when you went somewhere, why you went there, what time, who was there. He didn't do none of that. He just said, well, it just filled in the box. And then as far as to meet the statutory requirements for nail and mail, you got to go there 3 times before you can do nail and mail. However, when you do your nail and mail, hold on. Okay, so getting back to where we were here, it's important that you understand all these various different proceedings, because if you don't, you can find yourself in a very bad situation. It's important for you to have knowledge about this here. A person without knowledge, like I said before, is poor, spiritually, physically, every other way. However, it's important that he gain knowledge, that he become somewhat not rich, but he begins to have something in his pocket now of substance, of value. I think there was a record that came out and said, what's your net worth? They was really talking, she was talking about her money, but she talked about the value of how people value her, that says her net worth is this amount of millions of dollars. Okay? It's very important that you understand these things, brothers and sisters, because in the end, we have to get what we deserve. But if you don't train for this competition to get what you deserve, you're going to get what you deserve. You didn't do nothing. You didn't prepare yourself. Here's your 2 cents. That's all you got. It's a chapter in the Bible. I'm not a religious person, but it's a chapter in the Bible about a king that went away. He left each one of he had 10 subjects, and he left each one of them with a talent. And he went away. And when he came back, he asked them, all right, hey, how's everybody doing? He says, well, I left you with a talent. What did you do with it? He said, well, I invested it, and this is what I got back from that talent that you gave me. He said, very good, fine. He gave him his coin, gave him back his coin, and he got his portion. And he went so on and so forth down the line. And when he got to the last man, he asked him, what did you do with the talent that I gave you? He said, I was afraid of losing it, so I buried it. He did nothing with his talent. The king threw him in jail. It's the same thing that Negroes is going through out here for lack of knowledge of self. The jail is a prison, is a mental thing. It's an economic, social, and political thing because we're not trying to get somewhere for ourselves. Those spiritual stories result in conditions that we wind up having to live. So we need to understand these stories. There's many stories in the Bible that will give you a lot of understanding about life. And as you know, the prophet said, don't discard your Bible. We still, and C.M. Bey did say as well. He said there's still over 144,000 years of prophecy left. Over 144,000 years left of prophecy. So don't put your Bibles up. Learn your science and everything that's needed to be learned, but don't get rid of your books. Because a lot of things aren't as clear as you expect them to be. Some things have to be said in story form for you to start to exercise. See, the Moshe Quran says, thought must be developed by the exercise of strength. He didn't say go lifting no weights in the gym. He says, thought must be developed by the exercise of strength. Now, you look at that for what it is in the Moshe Quran. That's what it says there. Thought must be developed. So we go to the gym. That's here. We need to be lifting, bench pressing. We need to be bench pressing here. Thought must be developed. Thought. He said, so Allah threw forth his human seed, where? Into the soil of soul. And he said, what? It grew apace. But this is what's important, that it might become. Might. Not that you necessarily will. Because you got that other story that talks about the seeds that was thrown and some landed on where? On solid ground. Some rest on fertile ground. Some between thorns. Everything ain't going to grow. Some can't even take root because of the mindset that they're under. Not that those are the seeds, that's the knowledge that people are giving you. But because of your hard-heartedness, you probably can't comprehend it. Or anger. I don't know. I can't say what it is. But my job is to make sure I bring this information and this message to you. And you take it for yourself and start to read. So I just wanted to give this part of it. I believe the next time I do a video, I'm gonna have to share documents. I want to share these two affidavits that we did talk about. We have one that's dealing with the Moorish Science Temple of America. That your document, it says, I am a citizen of the USA. Okay. He says, you are Muslim under the divine laws of the Holy Quran of Mecca. All right. That all of this fits into the Judiciary Act of 1789, if you didn't know. But I want to see when I go live, hopefully soon, I'm gonna keep doing videos till I get enough. Like I said, I need comments and statements. I need to know where y'all at. I need to know what you see. And are we on the same page? Or you want to debate? Not a stupid one though, intelligent one. Okay, in terms of procedure, rules, how this goes. And I got this nice little book I just picked up. You might like it. Later on, we'll get into this. This is just the statutes anyway. This ain't nothing big. It deals with selected international human rights instrument. This is only the statute. This is not cases. And this is what I want to try to show you when it comes to researching what type of material you really need. Like this is a book. You need a handbook. The handbook basically is like a blueprint. And the blueprint show you where your connections go. Or why that connection won't go over here and why it go over here. So this is what handbooks is all about. I always buy handbooks when I buy them. And also I need you brothers and sisters to know as well. When you buy your books, try to buy them used. New costs too much money. You buy a book used, you can survive. You can buy more books. Anyway, I just wanted to give this portion of it. We're going to stay in that Judiciary Act pertaining to those 5 sections. Okay. And then we got 5 subsections. But on the last one, you got 3 subsections behind 5A, B, and C. Because you're dealing with the Moroccan Treaty in there. Okay. Then you're dealing with Moorish Science Temple of America in there. And then you're dealing with Resolution 75 in there. So you got A, B, and C. Subdivisions, which if you want, you can couple one from 1, 2, or 3 into A, B, or C. But really, when you hit the treaty part, you need international law. Now, you're going to get your international law inside the Judiciary Act of 1789. If you do exactly what I asked you to do, I'm gonna get some hits back from y'all. Again, when the time is right. Again, look up the Judiciary Act of 1789. Look it up in a PDF format. After you go to that section, go down to the bottom. On either section, you're going to find cases there. United States Supreme Court cases. So if you go to section 1, all the way through the end, you're going to find cases, historical cases that cannot be overturned. Okay? Presently affirmed. So I just want y'all to know this. We'll continue on at another date. All right, peace and blessings. And I hope y'all like this video. Peace.